good day to our lecturer, Madam Nina Lynn Friedrich, and my fellow friend. This is our group presentation that is Copper versus National Provincial Bank. So this is our team. The first is Shazliana, the second is Jade, the third is Celestina, and the last one is Hanafi.
A very good day to my lecturer, Madam Nina Lin Friedrich, and my fellow friends. My name is Muhammad Hanafi bin Jazdin. My student ID is 2021109419. The introduction and background of the case, Copper vs. National Provincial Banks is a legal case. The story of the Copper vs. National Provincial Bank, the bank failed to disclose that the principal debtor's husband was an undischarged bankrupt and that the husband had used the account improperly in the recent past. The court upheld the bank's agreement that there was no duty to disclose because of the contractual duty of confidentiality.
Greetings, my name is Shazliana. My student ID is 20211086339. Today I will present about fact about the case that Mr. John Rolfe, who had a property of her own, had an account at the Lancaster Gate branch of National Provincial Bank. Her husband Lionel Rolfe had been made bankrupt in May 1935 and remained undischarged in September 1942. The second case is Mr. Rolfe opened a second account at the Lancaster Gate branch in the name of the Val Farms Co. Mr. Rolfe is a sole trader trading under the business name Val Farms Co. The issue about this case is the plaintiff filed this lawsuit against National Provincial Bank, requesting that the two guarantees from September 25 and 28 of 1942 be declared void and annulled on the grounds that the bank failed to inform the plaintiff of these documents prior of the signing.
Greeting, my name is Jade Chomi, student ID 20211311379. I will present the court held and bank responsibility of our given case, which is Mr. Cooper versus National Provincial Bank. Firstly, after the plaintiff, which is Mr. Cooper, brought the case to court and urged the bank to declare the two of the guarantee to be void due to the bank failure to disclose the vital information for Mr. Cooper. The court has declared that Mr. Cooper's claim is unfounded because Mr. Cooper was unaware of the Mr. Rolfe authority to make a withdrawal from the Val Farm Co. account. Next is Mr. Rolfe was a bankrupt who has not been discharged at all relevant occasions, that the bank was unable to disclose this matter to Mr. Cooper that caused Mr. Cooper to enter into the guarantees and suffer loss. But the bank stated that he has signed the guarantee voluntarily, and the loss he suffered due to his negligence. Lastly, the check drawn on the account has been cashed, but the drawer has instructed the bank to not to pay to the one that present the checks. Due to all of the factor, Mr. Cooper has suffered loss due to the bank that unable to disclose important information to him. Next is bank responsibility, whereby the bank actually has an important responsibility toward both of their customer, which is Mr. Rolfe and Mr. Cooper, since both of them doing business with the bank. Both of the customer has the right to know the information of their current situation to avoid bigger problem in the future. The bank has the responsibility to provide accurate information for financial transactions and guarantees, and unintentionally withhold information that may violate the duty of disclosure when needed. By taking this action, the bank will not be blamed and can prevent any other problems that might burden the customer and the bank itself.
My name is Luciana Conrad and I will present the customer responsibility in this case. There are two customers of the bank in this case, which are Mrs. June Rolfe and Mr. Cooper. First, Mrs. Rolfe opened a Well Farm Co account and authorized her husband to use it. Mrs. Rolfe, as the owner of the account, did not advise Mr. Cooper that the account was overdrawn and certain checks were cancelled. Mr. Cooper signed the account guarantee without sufficient information and understanding of the risk of the signing the guarantee. As a customer of the bank, Mrs. June Rolfe has a responsibility to maintain her account in a good standing and to ensure that her husband did not misuse the authority given to him to draw on the account. She also had responsibility to inform the bank if there were any changes in her financial situations or if there were any issue with her account, such as overdraft or dishonest checks. Additionally, as a sole trader trading under the business name Well Farm Co., she has a responsibility to ensure that her business transactions were conducted in a lawful and transparent manner and to maintain accurate record of her operations. Next, Mr. Cooper. After learning the Well Farm Co account held by Mrs. June Rolfe was overdrawn, Mr. Cooper still signed the guarantee. Mr. Cooper later alleged that the bank failed to disclose that Mr. Rolfe has permissions to draw on the account, that he was undischarged bankrupt, and that certain checks had been dishonored due to stop payment order. The court ruled that the bank was not required to reveal this information and the assurances were lawful. As a customer of the bank, Mr. Cooper had a responsibility to exercise due diligence in his dealing with the banks and to ensure that he fully understood the terms and risks associated with any financial transactions he entered into. These include understanding the nature of the guarantee he signed, the obligations he assumed by signing them, and the potential consequences of defaulting on those obligations. Mr. Cooper should have done a thorough background check on the person he was insuring and looked into their finance. In this case, he should have done some study to find out that Mr. Rolfe, the person who got the guarantee, was still in bankruptcy. Such knowledge would have been very important for figuring out the risks of signing the guarantee. In conclusion, this case shows how important it is to understand the terms and conditions of financial deals, especially when a guarantee is involved. Before signing anything, guarantors should carefully look over what they task and make sure they understand them. Also, banks have a duty to tell people important information, but this duty has its limits. In this case, the court ruled that Mr. Cooper had gotten enough information from the bank and that it didn't have to give him any more.